evening and welcome to Littlefish Foundation's workshop on legal paradigms in blockchain and crypto. My name is Cem Karaca and I'm thrilled to be your host today. We are here on this virtual platform to explore the complex legal landscape of blockchain technology and cryptocurrencies. We are privileged to have two experts from Tevetoğlu Legal, Batuhan Demirtaş and Asena Ömer. Our agenda is as follows. Crypto Conundrum, a deep dive into the maze of assets and regulations across borders. We will explore the different types of coins and tokens and how they interact with regulatory bodies like SEC and CFTC. In Blockchain We Trust, an exploration into the legal paradigm of smart contracts, focusing on the evolution of trust in transactions and the legal frameworks that govern them. Open floor for community questions. You have the opportunity to interact with our experts and engage in further discussions to gain more clarity. Any doubts and queries can be addressed during this engagement. Closing remarks, summing up the takeaways. Thank you for your attention. Let's proceed to our webinar without any delay. Batuhan, can you open the presentation?
Hello, everyone. I hope everyone is doing great in these challenging times. I am Batuhan Demirtaş, and tonight with Asena Ömer, we will be talking on smart contracts and after that, tokens and coins. Before we delve into the world of smart contracts and their integration to governance, digital era, it is essential for us to revisit the foundational aspects of traditional contracts. In Turkey, the Law of Obligations number 1698 provides a clear definition of what constitutes a contract. According to the Article 1 of this law, a contract comes into existence when two parties declare their intentions and provided that these intentions actually align. Now you might wonder what exactly is this declaration of intention. Simply put, it's an overt or covert signal given by one party that they wish to enter a contractual agreement. Think of an offer as a handshake extended by one individual, known as the offerer. This gesture seeks a response if the individual on the receiving end accepts this handshake, or namely the offer. We have what's termed as acceptance. But actually there's a catch. This acceptance must mirror the original offer. If it doesn't, it's not an acceptance. A fundamental element to remember is that for a contract to form, the intent of both parties must be mutual. They both need to be on the same page, and while this might seem actually obvious, there are some other conditions a contract must satisfy to be valid. First, the parties involved must possess the legal capability to enter into a contract. The core of the contract shouldn't go against any mandatory rules of law, societal morals, public order, or individual rights. It is also paramount that the subject matter of the contract isn't something that is impossible. And lastly, the intention behind the contract should be sincere. It shouldn't be masked by any form of deception or threat. But, and actually this is crucial, there are some instances where lawmakers necessitate a particular form for a contract. If not adhered to, such contracts could be null and void. The term smart contract might sound very contemporary, but did you know that it was first introduced almost 3 decades ago? In 1994, Nick Szabo brought forth the term and described it as a computer processing protocol that enforces the term of a contract. Imagine a contract that activates itself, runs on a digital platform, and the terms of the agreement are part of its very code. In 2019, Italy stepped into the arena, legally defining a smart contract as a computer program running on distributed ledger technologies, also known as DLTs. This program, once activated, automatically brings together 2 or even more parties based on the preset conditions and outcomes. In Arizona, USA, they have a more detailed perspective actually. There, a smart contract is seen as an event-driven program with state. It operates on a decentralized and shared ledger and has the authority to manage and direct assets on that ledger. On the other hand, if we look at Illinois, they define smart contracts as electronic records of agreements authenticated by the unique nature of a blockchain. In Turkey, as of September 2023, there isn't a legal definition for smart contracts, nor are there any whispers about imminent ones. In our journey to grasp the full potential of smart contracts, it is vital to understand their core characteristics. So, what makes a smart contract actually smart? First, foundation on blockchain. Smart contracts aren't just documents, they are computer programs generally residing on a blockchain. Secondly, immutability. Once established, a smart contract is like a pact set in a stone. It cannot be altered, ensuring the integrity of the agreement. Thirdly, decentralization and peer-to-peer interaction. Unlike conventional contracts that might actually involve multiple intermediaries, smart contracts thrive in a decentralized environment. Parties can interact directly, minimizing potential delays and conflicts. Last, automatic execution. One of the cornerstones of smart contracts is their ability to self-execute. Once terms are met, they spring into action, ensuring each party fulfills their end of the bargain. Next slide, please, Sabrin. The structure of smart contracts presents a challenge in comparison to traditional contracts. Let's examine these two types of contracts side by side and try to understand their strengths and their challenges. First, complexity of provisions. Traditional contracts often come adorned with multiple layers of provisions, accommodating various scenarios. Smart contracts, on the other hand, are written in code. This coded nature can sometimes struggle to replicate the complexity of a traditional contract. However, innovation has a way of bridging gaps. Imagine a mixed contract where certain provisions are textual while others are coded. Such hybrid solutions can actually merge the best of both worlds. And secondly, electronic signatures. Smart contracts inherently require digital signatures. However, in Turkish law, not all contracts can embrace these electronic signatures. Specifically, the electronic signature law number 5070 throws a wrench, deeming certain smart contracts and electronic signatures invalid if they actually relied on these signatures. As of September 2023, blockchain-based digital signatures haven't yet earned their legal stripes in Turkey. Thirdly, scope of applicability. One might think that smart contracts are strictly tied to the blockchain assets, but actually this is a myth, and smart contracts work on the principle of ifs and so. If a condition is met, a corresponding action ensues. But how does the coded contract know if an external condition is satisfied? And actually, here is where oracles come to action. Oracles are generally third-party entities or persons that feed external data into the smart contracts. With their help, even non-blockchain assets can be governed by smart contracts. So our next slide, please. Smart contracts in the eyes of law. What exactly are smart contracts in the eyes of laws? And how do they fit into the legal framework we are actually familiar with? At its core, a smart contract transfers the rules and conditions of a contractual relationship, a contract, into computer code. These aren't just mere rules, and they are conditions that dictate when and how a contract will be automatically executed by itself. Some scholars see smart contracts as the technological evolution of traditional contract performance, execution of contracts. For instance, once parties draw a standard contract, its provisions like transferring the digital asset, payments, rights, the transfer of rights, and etc., can be automated through a smart contract. It is akin to signing a contract on paper, a traditional contract, and after that, employing a robot to carry out its terms. One other thing is the individuals coding these smart contracts are mainly technology experts and not necessarily legal or commercial experts. Therefore, we often recommend to have a guiding document, a blueprint that details the essence of the agreement. Aligning this blueprint with traditional contract makes resolving potential legal dilemmas, conflicts surrounding smart contracts actually more manageable. To sum it all up, while legal waters around smart contracts are still murky, actually one thing is very clear. We are at the peak of a legal revolution. And as the realms of technology and law continue to intertwine, it's imperative that we keep pace, understanding, and adapting to the evolving landscape. Now, I would like to, pardon me, talk on legal developments in smart contracts in general. In Turkish law, there is no legal regulation addressing smart contracts and blockchain technology in all of their aspects. The reason for this may be the complexity of these technologies and the inability of states to keep up with the pace of technology. The process of making regulations are actually very slow. Marcus wrote something. I will be addressing that after the presentation. Thank you. However, especially in Europe and United States, the important studies are being carried out in this field, and some of them are starting to become regulations. Developments in Europe. Belarus was the first country in the world to legislate on smart contracts. According to a 2017 presidential decree, a smart contract is defined as a program code intended to function in a distributed ledger for the purpose of performing various transactions, automated execution, or other legal actions. A report from the Legal Affairs Committee of the European Parliament highlights the increasing use of smart contracts, but raises some concerns about their legal validity and the enforceability of these smart contracts. The committee calls on the European Commission to establish a legal framework to provide the certainty for businesses and consumers, particularly regarding the legality of smart contracts, their use in cross-border transactions, and meeting formal requirements. The committee also recommends implementing mechanisms in smart contracts to hold their execution in certain situations, such as protecting the weaker party or creditor rights. However, actually, it's safe to say that there is currently no legal regulation on smart contracts in terms of European Union. But in recent years, Russia has actually made notable progress in the field of blockchain. A significant development was the amendments made to the Civil Code back in 2019, which acknowledged the possibility of self-executing contracts through electronic means. This has opened opportunities for smart contracts without the need for manual intervention from the involved parties. Development in the United States are far progressive, actually, and the US does not have a consistent national regulation on blockchain or smart contracts, what's normal for the United States. And however, federal agencies like Commodities Futures Trading Commission and Securities and Exchange Commission have released several reports, stating that they do not believe special regulations are needed, and they are instead applying existing laws to smart contracts. Before we examine their approach, we will be talking on several states. For example, Arizona has become the first state in the United States to acknowledge the legal validity of blockchain technology and smart contracts. The 2017 legislation states that smart contracts executed on a blockchain are legally binding. And Frankie, your mic is open. I will continue. Smart contracts executed on a blockchain will be legally valid even if they do not follow the traditional format of a contract written in human language. This recognition is a significant step forward and actually sets the precedent for other states to follow. The state of Tennessee, on the other hand, passed a law in 2018 that defines blockchain technology and smart contracts. This law, like the one in Arizona actually, states that smart contracts are legally valid and enforceable. They might be. In 2019, the Arkansas implemented regulations like Arizona's and legally recognized blockchain technology and smart contracts. This makes it safer for parties to choose Arizona or states that have similar legislation that acknowledge smart contract as legally valid and binding when entering a smart contract relationship. The state of Illinois has taken significant steps by passing Blockchain Technology Act, which in fact allows the use of smart contracts. This law defines smart contract as contracts that are verified using blockchain technology and stored electronically. This is important because it legally recognizes smart contracts as valid contracts. Wyoming has a comprehensive set of laws and regulations, including the definition of smart contracts as automated transactions that fill contract terms. These definitions align with the belief that smart contracts are a means of enforcing legally binding contracts, performance of contracts. Now I will let Asena take over. Thanks for listening.
Thank you.
Hi, everyone. We maybe forgot to add the developments in UK in the slide, but I will briefly talk about that as well. Let's continue with the developments in the United Kingdom. So the United Kingdom Law Commission released a report about smart contracts in November 2021. So they basically said that smart contracts are legally binding agreements where a computer program does some or all of the contract necessities automatically. They also pointed out how popular smart contracts are getting in things like real estate and supply chain management. So the Law Commission also listed 5 things that need to happen for a smart contract to be legally valid in England and Wales. These things basically are agreement, consideration, certainty, completeness, intention to actually make a legal agreement between the parties and following any necessary formalities with them. So we can continue with the agreement requirements for smart contracts and follow the slide as well. There are some requirements for smart contracts to have within them. So I would like to talk about them. When people agree to a contract, it's usually because one person offers something and the other person accepts it. So this is similar to how it works in Turkish law as well. An offer is a clear statement of what one person is willing to do, and it shows that they want to be they want to be bound by the terms of the contract. So the person making the offer expects it to be enforceable as soon as the other person accepts it as well. On the other hand, acceptance means fully and clearly accepting the terms of the offer. If there is a clear intention to create a legal relationship and all necessary elements are there, then an agreement is formed. Let's talk about consideration. Usually you can't make promises without getting something in return, as stated by English and Welsh law as well. We think that smart contracts won't be a big deal when it comes to figuring out what counts as consideration. In most cases, you can look at the wording of an agreement or how the code works to see if there is some form of payment involved, like money or tokens. So consideration is generally very clear within the smart contracts. There is another requirement, which is certainty and completeness. That should be in the smart contracts. Certainty is all about having enough details in a contract. So the contract terms should be crystal clear so that everyone knows what they're responsible for. Remember, if the terms are unclear, the contract might not hold up or could be totally useless or worse, invalid. So completeness on the flip side is kind of like certainty. For a contract to hold up in court, it has to be complete. That means both parties need to agree on all the important provisions. If they only agree on some things and leave other important things unclear, there might be not be a valid legal contract within their hand. So when it comes to smart contracts, it all depends how complicated the agreement is. If the parties can agree on the basic terms using a smart contract, then that contract will be considered to meet these requirements as well. And there must be an intention to create legal relations. That's another requirement as well. So this rule is meant to tell the difference between contracts that are legally binding and those that are more informal and not meant to be legally examined. So the Law Commission says that when using a DLT system or smart contract platform, it can be hard to know if parties intended to have a legally binding contract. So it's a good idea for parties who want their transactions to be legally binding to clearly state that in simple terms. Just like Turkish law, there is a formality requirement as well. The basic rule is that contracts don't have to be in a specific form unless the law requires it. So smart contracts are no problem for matters that don't need a specific form. However, for the matters that they require a specific form, which is be like in writing, smart contracts need to be looked at. So the Interpretation Act 1978 defines writing as including all ways of representing words visibly. So as long as the words of a contract can be represented, a smart legal contract can meet the in-writing requirement. So it's basically very simple to do. The tricky part is if the code can be read by a person. So the Law Commission believes the source code counts as writing under the Interpretation Act, but it's harder to argue that a smart legal contract is in writing if the terms are stored in machine code or a lower level of code. So basically, we are saying that they should be it should be available to read by other persons as well. Can we move? Yes, thank you. So let's talk about validity of smart contracts and valid use cases. Smart contracts are mostly valid if they meet the requirements of traditional contracts. So the main challenges in validating smart contracts are related to their form. If a contract does not need to be in a specific form, then smart contracts are just as valid as traditional contracts. So it's basically, like I said before, in Turkish law, there is an example. Contracts for transferring real estate ownership must be officially written and signed in the presence of a notary public. So to avoid legal risks, smart contracts should not be used for contracts that require a specific format such as this. If we are talking about a contract that will need a requirement to, for example, as I said, before a notary, that cannot be done with a smart contract for now. But in cases where a written or stricter form required is not needed, smart contracts can be considered valid. For instance, agreements. For instance, agreements for transferring digital assets like Bitcoin can be made and executed through smart contracts. However, in Turkish law and many other jurisdictions, written contracts usually require the parties' signatures, which can be tricky in the context of smart contracts because in Turkish law, only certain electronic signatures are equivalent to traditional signatures, as also Batuhan mentioned. So it can be concluded that under Turkish law, smart contracts are not valid contracts for contracts that require a specific format only, but they can be used for contracts that don't have such a requirement. Can we change that? Yes. Depending on what a smart contract is used for, there could be different legal scenarios to think about. So smart contracts can be used to create new tokens like NFTs, hold on to crypto assets for a while, or work as a governance tool for certain tokens and so on. So let's talk about minting. It's super important to really check and test these smart contracts before using them, since blockchain transactions can't be undone. Any mistakes or weak spots in the contract could mean losing money or having other bad things happen. You should be careful and make sure everything is secure. lots of crypto assets like NFTs get made using smart contracts. So when you're making tokens or NFTs on platforms like Ethereum or Binance Smart Chain or other examples, you have to have smart contracts to do the minting. So these contracts basically have a way to create new tokens or NFTs as well. And when you use that function, it adds more tokens to the overall supply and gives them a specific address. And when new tokens or NFTs are made, the smart contract can let other apps or wallets know with events. This also helps keep tracking of token creation in real time. But we can talk about vesting. There is no specific requirement for vesting agreements in Turkey. So it's pretty safe to say that smart contracts can be valid and enforceable in this manner. Smart contracts are super important in the vesting process for cryptocurrencies and tokens. So they can make sure that vesting schedules happen automatically and transparently. So the smart contract will release tokens bit by bit following the vesting schedule. Then the beneficiary can claim those tokens. When it comes to smart contracts for vesting, it's always crucial to have audit and testing. It is recommended. So mistakes in blockchain transactions can't be reversed, as I mentioned, and can lead to big losses or legal problems. So this is advised. Let's talk about governance tokens and smart contracts. In DAOs, the communities agreed upon rules are enforced through smart contracts, and voting takes place using these contracts. The codes that contain all the rules and operations are made available to the public. So once the smart contracts and governing rules of a DAO are in place, the tokens of the DAO are usually offered to the public. So by buying these tokens, people become members of the DAO, which gives them the right to vote and be entitled to any profits generated by the DAO. So in conclusion, our recommendation is that before using a smart contract, parties should always check if the agreement requires a specific format based on the subject matter of the DAO. So smart contracts are an important part of DAOs and their governance tokens. However, it is very worth noting that the legal status of DAOs in different jurisdictions can affect the validity of smart contracts. We also made another paper on DAOs. So maybe if you want to check that out as well, there are further information, which will also connect to this part of the presentation. I would like to also add, okay, yes, please stay. I would also like to add an example. If DAOs are considered joint stock corporations, for example, if DAOs are considered joint stock corporations, many governance decisions may need to be in written form and include signatures from authorized personnel. So one of the main ways smart contracts are used in DAOs. Once a DAO is established, the funding process begins. So during this time, people from all over the world who want to be part of the DAO can buy its tokens. So these tokens are sometimes called governance tokens because they allow holders to participate in voting and have a say in how the DAO is run. Let's continue with the legal risks in smart contracts. Thank you. Another issue to think about is the Oracle problem, where a smart contract relies on information from an outside database. If that database doesn't work properly or provides false information, it becomes a problem, obviously. It can also be hard to understand a contract that is mostly written in code, which can lead to problems. Translating contracts from code to regular language can also cause mistakes and disputes because of confusion about the meaning and intention of it. Fixing these mistakes can be difficult since changing code on a distributed ledger is not easy, which increases the legal risks. So there are some legal problems and the risks that smart contracts may have. The way smart contracts are set up and how much they are automated can affect the chances of having legal dispute or complications when using them. I would like to give you a case. We only found an example with the German Federal Court of Justice, which made a decision in a case where a French bank was offering lease agreements for batteries used in electric cars. So this is seen as an example of a smart contract being used in a car lease agreement. the court discussed that digital intervention in controlling a rental object is considered the same as physical intervention. So this means that whether the battery is accessed manually or automatically, doesn't matter, and automated intervention can be attributed to the bank's technology. So this suggests that using a smart contract to automate a lease agreement could lead to legal disputes. This is the only example of the cases in the world yet that we found. Okay. So let's talk about blockchain, smart contracts, and future notarial services. Notaries are really important in legal topics because they verify and prevent fraud. So they basically witness the signing of certain papers and make sure everything is legit. They can also act as a go-between for parties in making formal protests or declarations. So sometimes using a notary is even required by law because notaries keep official records of legal transactions. Some experts suggest using blockchain and smart contracts to make the process more secure. There have been cases of notaries behaving badly, so people want a more trustworthy system. So blockchain is good for this because it records transactions securely and transparently. The data is spread out across lots of computers, so it's protected. This makes it a good fit for notary services. So the World Intellectual Property Organization is even interested in using blockchain to protect data and make registering intellectual property rights easier and more secure. Thank you all for this topic, the smart contract. And if you have any questions, we would be happy to receive them with Batuhan. And maybe also, if you want, we can go on with the tokens and then answer the questions. But I think we can maybe talk about it a bit here for like 10 minutes and then move on with the tokens. Cembe, what do you say?
Sorry, we can have the questions in the meantime. Yeah.
I think so. Batuhan, also, if that's okay.
Any questions? Mehmet?
I'm trying to understand, is there any authority in the world about who is submitting the translation from code to the documents?
Not an authority, but we know that there are some corporations, counseling services that help people in this regard. But actually, it is not a necessity. It just makes it more manageable, more foreseeable. And when there is a dispute regarding a smart contract, the textual part, the translated part, may actually have a great impact on the solution of the dispute. But I will say it again,
So
there is no necessity to translate that.
There is a, for example, I'm thinking about, since there are no written requirements for now, I'm thinking about traditional contracts as well. So if you concluded an English contract in Turkey and you have a confliction between a Turkish court, you have to have those certified translators. So I think it is a requirement for courts now for traditional contracts. And maybe that can be another requirement for a smart contract in the future.
Because otherwise, the court, when they try to give any kind of solution, then it must that there must be some authority to understand the code totally when we look at the whole case.
Mm-hmm. Yeah, exactly. But there are not many disputes in the world right now. So maybe I think it will be a requirement in the future for sure, because for traditional contracts and translating wise, even if it's a code or not, from a language to a language, code is also a language. So I think it will be a requirement for a certified translator in that area would have to translate the document.
Also, when it goes to a trial, my take on this is that the judge will ask for expertise to translate smart contract into a form and into a language that judge can understand. And after that, the judge will be able to solve the dispute if he or she can.
Yes, I asked this question because whenever I'm a computer engineer, whenever I wrote a code, let's say smart contract, when I show them to my friends, which is also coder, and they can easily differentiate each other about the explanation or the also the outcome of the code. That's very difficult and the problematic issue.
And that's why we strongly recommend the blueprint or the translation, the textual form of the smart contract, so that parties also agree on, so that there will be no conflicts or disputes, or even if there are any, the solution will be much easier.
Okay, thank you very much again. One more time.
Thank you.
Mehmet, I can also add this. There are auditing companies for the blockchains that especially check smart contracts. These people are hired by the smart contract developer company, and you get the audit for your smart contract, and you show them your source code, and they analyze everything in means of security flows and if there are backdoors inside your smart contract. So this helps the communities for better and safe smart contracts. Marcus?
Yeah, I want to build up on the question that I've posted in the chat. I'm just going to read them out as a conclusion so that everybody is on the page who's watching the video on YouTube later. So thanks to your article, which I found really, really pleasant to read and a great write-up, I could derive that oracles seem to pose an inherent risk depending on their own risk to cease before the smart contracts expected end of time. And with that, through this through today, I have the other thing that comes up, and then I come to the my actual question. So it might be a theoretical advantage to keep a smart contract private as a non-public or partly off-chain to reduce legal risk, which is a more traditional centralized approach, but could be used to provide a more realistic dispute resolution model. And I'm just having this thought model that the advantage of a smart contract is the predictability. However, with the inherent risks that comes with it, might it be a better solution until we get to a point where we can be much more surer of sustainable oracles and other things that come with it, to limit the time of smart contracts to, let's say, half a year or so. So we take away the infinite advantage that we actually have from the smart contract to secure the developers of making a prediction that they promise that they cannot keep. What is your thought on this?
I actually strongly agree with you, because right now the oracles actually, as you said, possess inherent and serious risk. The smart contracts will be triggered and executed according to oracles and the data, external data that oracles will provide. And if the oracles knowingly or unknowingly provide the false data, then there will be severe consequences. And therefore, I agree with you that smart contracts, depending on their nature and their importance, it might be better to keep them private or non-public off the chain and etc. The oracle problem is actually a serious one, and there are some changes, developments that are need to be made.
So that's where DAOs and the voting mechanisms would be a great chance to say, okay, we repeat the smart contract as it is for another time frame, extended, so to say, and make it in this way kind of perpetual upon voting of the community. So that would actually get a real additional value.
Yes, I agree. And the blockchain technology and smart contracts actually enable the community to have a more democratic decision-making process and more reliable, sometimes, information. And I would like to also point out that if in a case that smart contract is not executed or triggered as was intended due to the malfunctioning or providing false data to the smart contract by the oracles, that actually may hold oracles liable to the parties of the smart contract. So actually, oracles in this regard have a huge burden on their shoulders, and they actually really need to be careful.
But I think the problem here is that most developers, sorry, boss, and Emir, then I'm stopping. That most developers are not aware of that risk in that case, of the legal implication, and will not point that out. If what you usually do in a legal term, where you say we're not liable for third-party fails, we can try to provide a failover, but it's not our liability if they seize on their service. And usually in a smart contract, you don't have that written down.
Yes, exactly. That's actually why we are trying to do this and to try to inform the community about the possible legal risks and consequences that members of this great ecosystem may unfortunately face. I hope we are getting somewhere, doing our best. I hope we are helpful.
I will go back into the queue because I have another question. Thank you.
Thank you for your questions.
Boaz, if you have questions.
Great, thank you. First of all, I'd like to thank our speakers and Littlefish in general. I have some general questions, and I will pick on little. The first one is having tokens proof of stake in all blockchains in the world. As I could hear, I can't know how to pronounce the name. She was talking about the governance having tokens that could allow people to have a voice in some blockchains. I would like to know if that's possible in all blockchains in the world. And the last question, how could we allow governments in third world countries to collect taxes on crypto while blockchain is sometimes considered illegal there? Yeah, like in my country, I'd like to say. Thank you.
I'm not sure if I get your questions accurately, but as far as I understand, there are different types of consensus mechanisms. One is like proof of stake, proof of work, and etc. Each of them has ups and downs. For example, how did you write your questions, Boaz? Is having tokens proof of stake in all blockchains in the world? I mean, different types of blockchains have different types of consensus mechanisms. Some blockchains work on proof of stake, some of them based on proof of work, and etc. So there is no uniform approach to what type of consensus mechanisms that blockchains shall have. But in recent times, proof of work consensus mechanisms has been criticized due to the fact that they need too much energy, which will actually causing some environmental concerns. And I will try to move on to your second questions. How could we allow governments in third world countries to collect taxes on crypto while blockchain is sometimes considered illegal? First of all, the fact that something is illegal does not mean that government can tax you on this. For example, if you go out and sell drugs in a jurisdiction that prohibits the selling of drugs, government, state will tax you on the income, on the money that you make from selling drugs. And in terms of taxes, we are not tax attorneys. And actually, our answer to your question will mostly depend on the jurisdiction and state you ask. And to be honest, I don't have much information on third world countries and how they collect taxes.
I had a paper regarding the taxes. I'm sorry.
Okay.
So it is hard to, it will be difficult to imply taxes on a country that is illegal to have crypto and blockchain systems. But generally, tax relies on if you submit a statement, then it will be taxable and then it will be noticeable. If not, you would, if it would be considered to be taxable, it should be a real big amount of gain for the authorities to catch up on. So that's another general answer I would like to say.
Also, we have prepared the paper on taxation.
We do have a paper.
I think Cem or Sabrin will share it.
Yeah, I can share it.
Chat. Thank you.
Okay, there are more questions I see, but should we also move to tokens and maybe take the last questions?
Yeah, I will take the last two questions and after that we can continue.
Okay.
Emir?
Everyone, I hope you can hear me.
Yes.
Yeah, I wanted to add some information about the oracles and a question after that.
Mm-hmm.
Some oracles, like OneChain, offer a solution to this corrupted data. They run nodes just like a blockchain. They gather their information from different sources, and each node operator has to provide the collateral for this operation. And if the data they provided is corrupted, they lose their collateral for this action. And my question is, do these actions of getting collaterals can be accepted by law? I have no idea about the law.
First of all, thank you for your additional information. The information you have provided is very important. Just based on the information that you have provided, I can say that this collateral system actually provides the reasonable solution regarding the false data, which may in fact result in loss or damages. But for a second question, I can't answer that because it depends on the jurisdiction, and there are different rules across the globe regarding collateral. And if you provide which jurisdiction that these oracles or the system that uses Oracle subject to, then we may provide some information on that.
Okay, thank you.
Thank you. Marcus, do you have another question?
Yeah.
Great.
Yeah, just this is an idea.
A question or idea?
An ideal question. It's also going back to this Oracle thing. Is it a model that you're thinking about that is being thoughtful to add legal disclaimers as it is already use case right into the code at the particular code piece, like as a comment?
Mm-hmm.
Like if you would say have this connection to the Oracle, and then you say, okay, here we have a non-binding agreement. Although we have written the code, we cannot be liable for third parties to fill over. And if that case applies, then we will have to revoke the smart contract and set up a new one or something like that. Would that be something that could work?
Again, I really hate this answer, but depends on the jurisdiction. But for Turkish law, I can say that some types of disclaimers has no legal effect, regardless of how many attorneys write these disclaimers in their end user agreements, smart contracts, or anywhere. However, the fact that you wrote that doesn't make you secure. For example, markets in crypto assets regulation clearly states that a disclaimer, a type of disclaimer which I can't really remember right now, has no legal effect in terms of liability arising from the white paper. And in terms of Turkish law, I can say that some disclaimers are also has no legal effect, because law obligations has some articles that state specialized people who work on or provide services on specific areas has the obligation to provide good service. And disclaimers in this regard are ineffective, has no legal effect. So I believe disclaimers that you asked will be actually invalid for Turkish law. But I have no idea about other jurisdictions. I have to look it up. Are there any questions in the chat?
Thank you.
You're welcome.
Thank you. Let's continue to part 2 and learn about the blockchains, coins, and tokens.
Okay, let's begin. Now, we'll explore the intriguing world of crypto assets and their legal aspects. Blockchain, the bedrock of our digital finance era, governs a spectrum of assets ranging from cars to artworks. Two pivotal terms in this are actually coin and token. While they often intertwine, especially in initial coin offerings, actually they hold distinct meanings and uses. Crypto assets can be coins, tokens, NFTs, smart contracts, and basically all representing digital value or some kind of rights or obligations. Their classification often hinges on the underlying blockchain. And for instance, blockchain and Ethereum are layer 1 blockchains, and they are primary assets. Like Bitcoin represents coin, while the derivatives of such coins are called tokens. Beyond the technology, tokens and coins navigate a maze of technical and some legal considerations. The nature of a token can significantly alter its legal status, especially concerning initial coin offerings, ICOs, and depending on the jurisdiction and regulatory oversight. Sabrin, you can move on to the next slide. And first, I would like to address the question, what is the difference between crypto assets and fiat currencies like euro, dollar, and etc. Many people equate crypto assets to traditional fiat currencies like dollar. However, there is a distinction. Fiat currencies are closed ledgers controlled by governments. On the other hand, crypto assets generally are open ledgers, transparent, and in fact, some cases more democratic. And the fact that some governments have mishandled their financial power over the people, causing inflation. In the crypto realm, many crypto assets are inherently capped. There's a maximum amount of token or coin that could be issued or minted. And actually, this offers a buffer against such inflation. I would like to address types of coins, and first one is Bitcoin. Bitcoin is the pioneer of cryptographic coins and undeniably the most discussed digital asset of the past decade. Its decentralized nature and role as a payment system actually aligns it with banking law and related legislations. We will be examining this matter more in detail. Altcoins, on the other hand, is a term stemming from alternative to Bitcoin. Altcoins rose after Bitcoin's success, aiming to offer superior features or to bypass existing technical or legal limitations. And the price of Bitcoin and altcoins is set by the free market via various trading platforms. And these platforms are generally called crypto asset service providers in terms of legal context. But differences in values can actually lead to arbitrage, and people use that. Moreover, regulatory considerations for altcoins actually pivot on their functionality. For example, banking law will be most probably applicable if they lean towards becoming an exchange, and capital markets laws will come into play if they resemble capital market instruments. Also, as I work on my master thesis, I come across a data from World Bank, which actually shocked me and didn't really shock me at all. The efficiency of crypto-based transfer system is evident when we examine transaction fees. Hear me out. In 2016 alone, fees for money transfers stood at $575 billion, and which is actually equal to Turkey's GDP on that year. Such significant costs spotlight the need for a more cost-efficient system, making many people, many scholars, question the motivations behind certain regulatory restrictions on crypto assets. And moving on, stablecoins. Stablecoins have values fixed to tangible assets like gold or established currencies or real estate or etc. And their legal considerations generally align with the regulations governing their underlying assets, especially under asset-backed securitization rules. So we can move on. And for security tokens, I would like to tell you about Turkish capital markets law. Capital market instruments set to encompass securities, derivatives, and other instruments deemed suitable by the board, capital markets board, and they are inclusive of investment contracts. Securities, on the other hand, as defined in Article 3 of the Capital Markets Law, include shares, securities akin to shares, and debt instruments. Also, money, checks, policies, and bills are excluded from this classification, so they are not securities. And I would like to draw a parallel with US regulations. In the US, the Howey test, I believe many of you heard it, is employed to determine if an asset qualifies as a security. Similarly, if a token aligns with the definition stated in Turkish law, it is considered a security. Transactions revolving around such tokens, like issuance, custody, will be then governed by this capital markets law and result in branding these crypto assets as security tokens. And given the inherent regulatory complexity, opting to launch a security token is not advisable as of now. There is a host of strict regulations that expose issues to considerable legal risk. And we actually see that in the United States. SEC and Commodities Futures Trading Commission filed some complaints regarding the tokens. Also, there is something interesting that I would like to talk about. We call this the ripple effect. Should the primary coin be labeled as a security, there is actually a possibility that all tokens derived from the same blockchain might also inherit the security tag. This is primarily because these tokens, being byproducts of the main blockchain and the coin, can see their values influenced by the parent coin's performance. So they are interconnected and frankly affected by each other, which in fact result in considering these derivative tokens as security tokens, which is actually undesirable. Payment tokens, secondly. A payment token is a type of token that is used for payment transactions and has a dominant role as a means of payment. Tokens in this category are the closest in type to coins. And coins and payment tokens are actually very similar. The general tendency is not to accept the use of crypto assets for payment purposes. For example, in Turkey, central bank yönetmelik regulation banned the usage of crypto assets altogether, direct or indirect. Thirdly, utility tokens. The tokens referred to as utility tokens, or sometimes service tokens, offer their holders the right and opportunity to benefit from a particular product or a service. They are not securities, capital markets, or payment instruments. They can be used within the ecosystem in which they are issued, and enabling a product, a service, or a privilege to be utilized in the usage areas listed in this very limited actual network. And characteristic examples of these utility tokens are fund tokens issued by sport clubs that provide the right to participate in decision-making processes regarding their teams' anthems, uniforms, regulars, or substitute players, and even transfers. Although FIFA regulations do not allow for tokenization regarding transfers of players, but compared to other token types, utility tokens are currently the most distant from the binding mandatory terms and rules of banking and capital market law. And markets in crypto assets, MiCA. MiCA's distinction classifies this type of tokens as a utility token and point out that they are assets that have no financial purpose and are not used for that purpose. And issuance or treatment of such assets does not require any special authorization, provided that the offered utility exists or is in operation during its offering to the public. Therefore, launching tokens as utility tokens, or more accurately, actually, launching utility tokens is recommended due to its nature and forbearing minimized legal risk, unlike security tokens. And NFTs. Perhaps NFTs are the newest but no less popular of crypto assets. Legally, there is no widely accepted definition. Given its characteristic structure, an NFT can be described as a unique cryptographic asset, while other cryptographic entities can be substitutes for each other. NFTs are unique and single. Actually, NFTs are commonly perceived only in relation to intellectual property. However, any entity can be expressed in NFT form, and since uniqueness and originality are the characteristics most needed by intellectual and artistic works, producers of intellectual property products are much more interested in NFTs. However, NFTs can be used for actually anything, as long as law says it's okay. And asset-backed tokens. Asset-based tokens are issued based on either another crypto asset, or a digital asset, or a physical asset. They usually refer to a legal tender, a currency, one or several commodities, one or several other crypto assets, generally with the aim of maintaining a fixed value. But there are some exceptions as to everything. In MiCA classification, such assets are characterized by the function of storing a fixed value, and a white paper is required to explain the underlying asset and its functions in issuance and offering transactions. Actually, we have prepared another paper on white papers, and we will be also talking about them in near future. Examples include need for underlying assets to be available and maintained by the issuer, equity coverage, and certain provisioning requirements. Sabrin, you can move on to the next slide, please. And legal qualification of crypto assets. We really like to talk about SEC's stance on crypto assets. The SEC determines whether a token is considered a security based on the criteria set by the Supreme Court case, which is also known as SEC versus Howey. If a token meets the definition of an investment contract, it must be registered with the SEC before being sold or delivered. And what is the definition of investment contract? It is outlined in this case. The Supreme Court established a test for determining this and stipulated that Howey test, defining an investment contract as a scheme involving the investment of money in a common enterprise with profits to come solely from the efforts of others. In conclusion, since Bitcoin and blockchain do not constitute a common enterprise, and the value of the Bitcoin do not depend on the performance of the third parties, the simple fact that Bitcoin is not issued or controlled by a group or entity, and Bitcoin is generally regarded as a commodity by CFTC, Bitcoin do not meet the criteria set for the Howey test and therefore cannot be regarded as a security, which is important. And SEC has faced some serious criticism for applying an outdated case to new technological innovations. Many scholars and critics argue that using a case from 1946 for the crypto asset market, and in fact, which only emerged in 2008. The SEC has also been accused of providing unclear guidance and favoring early tokens like Ether while rejecting new market participants. Now I would like to address SEC versus Binance case. In this case, SEC complained, being as it sought to charge the Binance with 13 separate claims of breach. It is quite comprehensive and it involves all parties from the Binance side. SEC claimed Binance and bomb trading under the leadership and control of Zhao, which we all know, were unlawfully offering essential securities market functions by operating as an exchange, broker-dealer, or a clearing agency on Binance platforms without prior registration with the SEC. And basically, Securities and Exchange Commission said that you are providing securities market functions and you are operating as an exchange, broker-dealer, or a clearing agency, and you are supposed to register with us prior to your services, but you didn't, which in fact is a breach of securities law, capital markets law. The SEC claimed that Binance was aware of the necessity to register these functions, yet actively choose not to, which in fact means to avoid regulations. Binance itself was also considered to have been operating without registering as an exchange, broker-dealer, and clearing agency. One other important case that we would like to talk about is SEC versus Ripple. In this case, SEC filed action against Ripple Labs and its executives, Bradley Garlinghouse and, if I'm not mistaken, Christine Larsen, in December of 2020, claiming that they had raised over approximately $1.3 billion through unregistered digital asset securities offering. SEC claims that you offered digital asset securities which are unregistered, and you basically raised $1.2 billion. According to the SEC, Ripple, Larsen, and Garlinghouse had violated Securities Act by offering unregistered securities. All the defendants were in violation due to the sale of XRP without a registration statement in effect. And by offering to sell XRP, which was offered and sold as securities, as to which no registration statement had been filed, in early 2023, the SEC and defendants filed for a summary judgment, and the court decisions focused primarily on the 4 categories of XRP transactions and whether they establish an investment contract according to the Howey test. First and main issue was concerning the 4 categories of XRP sales, which are institutional sales, programmatic sales, other distributions, and sales of XRP by executives Larsen and Garlinghouse, on various digital asset trading platforms. First of all, institutional sales refers to sales of XRP made directly to institutional investors, and programmatic sales are sales of XRP made on digital asset trading platforms. Other distribution refers to distribution of XRP to employees or other third persons. As a matter of fact, court decided that although institutional sales satisfied all the prongs of the Howey test, in regards to the rest of the categories whereby XRP was sold, for example, programmatic sales, other distributions, and sales made by Garling Larsen, court said that we cannot find sufficient evidence that stated they would satisfy all elements of the Howey test. So basically, court said that institutional sales were sorry, I'm a bit tired. Institutional sales were unlawful, but other types of sales were actually no problem. And I would like to let Asena take over.
Thank you, Batuhan.
Asena, please continue.
Okay, can we move forward with the slide, please, Sabrin? Okay, so let's talk about what regulations should be adhered relating to each crypto asset. So we will have to break down them again. Bitcoin and other cryptocurrencies were created to replace traditional currencies in financial systems, basically. So they serve as a medium of exchange for economic transactions. The regulations that apply to a specific cryptocurrency are determined by its unique characteristics and purpose. So coins which aim to be a substitute for traditional currencies are likely to be subject to laws related to banking, finance, and payment systems. In Turkey, the central bank has classified crypto assets with monetary characteristics and has implemented regulations to prohibit their use in exchange and the development of payment systems that involve crypto assets. So we should examine each token separately regarding the relevant regulations. Well, so let's talk about security tokens. They are especially designed to comply with security laws, which sets them apart from other types of tokens like utility or payment tokens. This may involve including clauses for investor identification, trading restrictions, and other legal obligations as such. So the combination of traditional securities regulations and advanced blockchain technology makes the legal landscape around security tokens quite complex. Tokens aren't exactly the same as securities, so it all depends on how the token is designed and what it's meant to be used for. For example, we talked about SEC in the US. They use something called the Howey test, as Batuhan mentioned, to decide if a transaction is an investment contract, and therefore it can be a security or deemed as a security. Batuhan also mentioned this test comes from a Supreme Court case way back in 1946. Payment tokens, let's talk about them. They are basically tokens that are mostly used for trading or as a way to save money. So since payment tokens are similar to coins, they mostly fall under banking and finance laws. However, it's important to know that the specific regulation may vary depending on the country. But generally, payment tokens are covered by securities or banking laws. It is also important to consider relevant laws and regulations regarding customer identification and preventing money laundering. Utility tokens are tokens that allow access to specific goods or perhaps services on a platform or a blockchain project. They are distinct from security tokens and payment tokens as they do not represent ownership or serve as a mean of exchange. So instead, utility tokens are primarily used to obtain future access to something, while they may resemble securities, particularly when offered in an ICO for profit. Different countries have varying regulations for classifying tokens based on their use and marketing. As utility tokens become more similar to securities, they are more likely to be subject to securities laws as well. However, currently utility tokens are considered to the safest option within the cryptocurrency ecosystem. And we also have NFTs, also known as non-fungible tokens. These tokens are special digital assets that can only be verified using blockchain tech. Each NFT has its own special value and can't be swapped out for another one, unlike regular cryptocurrencies. So when it comes to intellectual and industrial property, the focus of legal discussions is on originality, uniqueness, and singularity of the NFT. So when you buy an NFT, you usually only get ownership of the token itself, not the rights to the digital product or artwork. This can cause some confusions because owning an NFT doesn't automatically give you the right to make copies, share, or make money from the artwork. So while most NFTs probably won't be considered securities, there might be cases where the structure and claims of an NFT make it fall under securities laws. In summary, NFTs are mainly evaluated in terms of intellectual and industrial property, and tokenizing an asset without authorization could infringe copyright. So similarly, tokenizing a security as an NFT may violate securities law. So the regulations apply will depend on the nature and the features of each NFT and the underlying tokenized asset. Okay, we can move forward. How do you share the tokens and legal implications of them? So ICOs are a method for new projects to raise funds by selling crypto tokens. These tokens are similar to stocks in IPOs. The classification of ICOs as securities determines the regulations they must follow. Different countries have different definitions and regulations for ICOs. So it is very important to understand whether a token is considered a security or not. For example, airdrops involve sending free crypto assets to multiple wallet addresses as a way to promote or reward loyalty. However, airdrops still have legal implications, as the regulatory bodies may classify them as securities, and the recipients may be required to pay taxes on the value of the asset they received. In Turkey, there are some rules you have to know if you want to get into staking and avoid any legal trouble. So one big rule is non-use of crypto assets in payments. Basically, it says that crypto assets are like those assets made with fancy technology and shared online, but they're not the same as regular money, electronic money, or stuff like that. So this rule doesn't totally outlaw crypto assets by itself, but it does try to put limits on how they can be used for payments. The rules about safeguarding the worth of the Turkish money don't really say you can have a crypto asset account, but these rules have a bunch of transactions that you can do in foreign currencies, but they can't legally put crypto assets on that list since it's a regulation that is only certain money and certain currencies as well. So creating a foreign currency deposit account like staking, it's totally okay for now with the law. So it's safe to say that staking crypto assets can be recommended, but in private law, if it's not expressly forbidden, it is also a fair game to do staking. So that means you can stake any kind of crypto asset, even the stable ones or those linked to foreign currency or gold right now. The popularity of using tokens as a form of currency within decentralized platforms is increased with the emergence of blockchain technology. So tokens are essentially internal cryptocurrencies that can be used for transactions and accessing specific features on the platform. The regulations for crypto assets vary greatly between countries and regions, making it difficult for users to understand and comply with the legal requirements. So governments and central banks are particularly concerned about the use of crypto assets for transactions involving global accounts, regardless of anonymity. So regulations such as QIC and AML procedures are being implemented by centralized authorities to address the barriers preventing widespread adoption of cryptocurrencies. So many countries are quickly adopting these regulations in order to capitalize on the potential growth and opportunities presented by crypto assets. We can maybe talk countries. So El Salvador was like one of the first countries to be, Bitcoin is totally legit. And they even passed a law saying it's cool to use it for buying assets. In the second quarter of 2022, the Central African Republic hopped on the Bitcoin train as well and became one of only 2 countries to give it the official thumbs up as a legal currency. In the US, businesses who store or trade Bitcoin have to follow the rules of the Bank Secrecy Act as money services businesses. So the government sees Bitcoin as a currency or crypto assets as a currency that can be used as a stand-in for actual Although there are regulations to crack down on illegal stuff and shady financial behavior with certain cryptos, businesses can still use crypto assets to pay their bills. Let's talk about the European Union. They are cool with tokens and as an asset and doesn't think using them is illegal for now. So some member countries are all for crypto assets and have made laws to back them up. But the European Banking Authority is worried about the risks and doesn't have much control. The European Union is planning to drop a new law to regulate crypto assets all over again as well. In Canada, they treat crypto assets like commodities when it comes to taxes and view exchanges as money service businesses. So the country has put in place rules to stop money laundering and terrorist funding related to using crypto assets. As long as people follow these rules, they can freely use and trade crypto assets in Canada. Israel is all about cryptocurrencies like Bitcoin. Lots of businesses and ATMs there totally accept Bitcoin as a payment, even though it's not officially considered a currency, security, or asset. By the tax authorities, sellers still have to pony up a capital of 25% gain tax when they sell their crypto. In Australia, just like in Canada, crypto assets are seen as taxable digital assets. So if you buy, sell, give, or perhaps exchange crypto assets for regular money spent, you will have to pay capital gain taxes. But if you hang on to your crypto asset and watch their value go up, you usually won't have to worry about taxes. It's a good idea to keep track of your transactions, and it is recommended for both Australia and Canada. India has changed its view on crypto assets over time. So the finance minister wants to crack down on illegal use of virtual currencies, but also recognizes the potential of a blockchain in payment systems. So initially, the Reserve Bank of India prohibited regulated entities from dealing with crypto assets, but they eventually lifted that ban afterwards. We can talk about Japan. We have many countries in the list, so it will be a long list. In Japan, Bitcoin cryptos is seen as a digital asset rather than an official currency. So the government said that Bitcoin is not like money or a bond, which cause banks and security firms to have limits on dealing with crypto assets. So people and groups can accept crypto assets as a payment, but businesses that handle crypto asset exchange must be registered and follow rules since it was, I think, April 2018. In Mexico, there is a green light for cryptos, and the country is all set to regulate it as a virtual asset as per the fintech law they have. Businesses in Singapore are now free to decide if they want to accept cryptocurrency, but the regulatory authorities have also cautioned users about the risks that come with using cryptocurrencies. Saudi Arabia has also warned banks about the risks of using Bitcoin or crypto assets since the government doesn't provide any protection or rights to companies dealing with it. While it's technically legal, there are some restrictions in the banking sectors. On the other hand, the United Arab Emirates, the Dubai Financial Services Authority has begun regulating investment tokens and has made some very big changes to the rules for recognized cryptocurrency tokens since November 2022. Okay, so China, Qatar, Egypt, Algeria, Morocco, Nepal, Bangladesh, and Tunisia have all totally banned cryptocurrency assets for now. When it comes to Turkey, the Central Bank of Turkey has made the rule saying that you can't use crypto assets to pay for things. We also talked about payment models above, and you can't create or use any payment systems that involve crypto assets. So we broke down all the countries. We can talk about governance tokens and their legal implications lastly. So governance tokens usually fit into either security or utility. So in reality, it's commonly referred to as a utility token, but just calling it that doesn't hold much weight. Particularly in the USA, the SEC and other authorities are concerned with the token's name. So they would rather evaluate the token or coin itself instead of how it's labeled by the issuer. So governance tokens could potentially have features like voting rights that might make them subject to capital markets or commercial law. So it's really important for the issuer to think about the legal implications of the token's specific features. For instance, if a governance token allows its holder to vote in a company or partnership or gives them a share of the project's profits, it's very likely that the token would be governed by capital markets or commercial law. There will be regulations implied on this usage. So if you're thinking about treating a governance token as a security, the issuers will most likely be breaking the law. So in places like Turkey, the USA, and pretty much everywhere else for now, the issuance of securities is heavily regulated and requires permission from authorities. So it's crucial to make sure your project doesn't go against the rules of the capital markets and commercial law. And that was it for my part as well. Thank you all for participating. And we can take questions. Maybe I can also start with Miss Ece's questions in the chat. If Miss Ece is still here and hearing us. Yes. Okay. So you asked that let's assume that transactions are worth more money due to a disruption, due to an IT problem. We, in generally, as company attorneys, recommend going for execution proceedings for the amount that was unwillingly or by the company's fault went to the wallets of the user. So we are recommending firstly doing an execution proceedings, and then we can recommend an unjust enrichment case to follow up with that. And if we can prove that we weren't the fault and the user was not honestly doing these transactions and was aware of the situation and also didn't do anything about it, then we can also go to the prosecutor's office and make a complaint regarding fraud and request our money back as well. So that, I think that will clear out the first question. And how do cases regarding crypto assets progress in Turkish law? We have Masak. So I agree on the between the wallets that it cannot be tracked, and it is compared to a bank account. It's impossible to know if it's fraud or money laundering in the situation we're talking about. So what Masak did is that they highly regulated the KYC and requirements. So if you are in Turkey using an exchange platform as such, then you should also submit your ID, so they will know what your who you are and where you're from. And basically you have to be a Turkish citizen, or you have to have a passport, or you have to be in Turkey for some time. So there are some regulations to prevent fraud, theft, and irregularities, as you mentioned, by these regulations. And generally, they do QIC, AML, and the exchange companies can also submit forms, which I would call them, translation issue, sorry. Şüpheli işlem, sorry. Let's say,
suspicious transactions. Suspicious transactions.
Yes, suspicious transactions. Then if they come across to a suspicious transaction, they would let Masak know, which is an authority in Turkey, and they will look into it, maybe ban your account or stop transactions for a moment. So I think, I hope it's cleared out. And if you have further questions, I would like to take them.
Any more questions? I think everyone is tired right now.
Yes.
Okay, it was a great meeting. Thank you for presenting, both of you, Batu and Hasan.
Thank you. I think Ms. Ece also has another question. Let me read it. I think expert reports cannot access company systems. The company itself make these reports. So they also regulate within each other, and they have to do those because of the regulations that we have. So you are obliged to submit or let the authorities know if you see anything that is contrary to what it should be in the company. So that's an obligation, and if you do not oblige by that, there is a very big monetary. How much was it, Batuhan?
I can't remember. I don't remember.
Do you know? No. Okay, so there is a penalty for that if you cannot. If you come across to a suspicious transaction and you wouldn't let the authorities know.
It depends on the suspicious transaction and the amount of transaction. And
okay, and I think the question also comes to, like, if we are trying to talk about proving the problem was caused by the company or the user. So that's actually true, but if user is alleged for fraud, then the user must also claim that he or she was not on fault, and then the company must be, well, an expert should examine the company and their records in the system. So maybe the court can rule on that, and maybe that will be helpful in that case. Okay.
Also,
any further questions now? Okay.
Marcus had an input that I strongly
Mehmet?
Hello again. Can you hear me?
Yes.
Thanks one more time. I just want to ask about the custody wallets. I know about the exchanges, Turkish exchange, just like Paribu or the BTC Turk. I know they are a KYC system, know your customer, and they are obliged to obey all the rules about the Turkish laws. But how about the custody wallets? If a person, let's say, they make a crime with their custody wallets, let's say he is not obey with the AML and other CFT rules. Is there any attempt or is there any rule about in the Turkish law to the laws custody wallets?
The company, the crypto asset service provider, will put levy, hedges, or block the account, the custody account that crypto assets that are held in, which are in fact which belongs to the people that commits a fraud or anti-money laundering or etc. Other than that, crypto asset service providers actually cannot do much more than that.
Oh, you cannot register in Turkey. You cannot register to an exchange platform without securing your ID and without passing the QIA and AML systems right now. So I don't think that will be an issue, because it won't let you, the company or the platform won't let you register as a user, as I know.
I see that if I am a member of any kind of terrorist organization, then I can send any money to the outside of the Turkey, or maybe I can get the money from outside of the Turkey. That can be traced or that can be catched by the authorities in the Turkish security institution, right? Is that right?
Yes, partially correct. Well, it depends on the transfer between the wallets, but if you are going to transfer that money to a bank account, it will definitely take a rise with the Mossack. But what they do as the companies is like they also follow what you're doing. They also follow your transactions, not the authority, not the Mossack by itself, but the company looks up what you're doing during the transactions and where this money comes from and where this goes. So they are obliged to submit a report on any suspicious transaction that you would do. This can be based on who you are, where that money comes from, or how much that you're transferring.
Thank you very much.
Mm-hmm.
You're welcome. Marcus,
you are sure because of.
Yeah, my voice was very high pitched, so it was better. If you see, or if we see, I do, social media as Damocles sword of any token, with all the expectations that come with it. It would be then probably much better for projects not to hype that token, but just basically build and then say, okay, by the way, we have that token that will be functioning in our system, and then basically forget about it in order to not hype the expectation again.
Yes.
I think
fund tokens were a hype, but actually the bubble starts to. And
is it then dangerous?
Yes.
Is that dangerous for the projects then? Because I think that's exactly what the SEC is currently abusing.
Yes. Liabilities may arise due to the lack of utilities that are promised with that fund token. Customers or investors, basically, and an ordinary person will, when they buy the fund token, they expect some returns. They want to have some say in their teams. And if the team or the crypto asset service provider or the manager of the issuer of the project do not comply with its obligations, then of course there may some criminal or civil liabilities, even criminal.
But this isn't this then some kind of a trap situation where Mika says if a token is distributed, I mean, not only Mika says that, but I mean, mainly all of them say that. Regulations say that if a token is distributed, decentralized equally, and without a payment, then it has fulfilled the first parts of not being a security token. However, if you have it in a closed environment, you have, according to Mika, you have the option to distribute the token. And in a very small environment, then it's not a security token. But then you have a very, very fine line that you can walk across in order to not be on the security side, because you're making a private sale within a closed environment. If it is a sale and then it reaches the public, then you're in big trouble, most probably. But if you have it as an exchange token for a service within a, let's say you have a car manufacturer that works with this token to kind of compensate their suppliers, then this is having some sort of value for a later rebate or something like that. And this is totally fine, I think, in regards to Mika, if I understood this right. The point I'm trying to make and walking around the block is, the line is very, very, very thin, I think. If you read those regulations, it sounds like, or they read like, oh, this is all very clear. This is all very easy to understand. But it's just one little step outside this tiny circle, and you're already in the other pond. Is that correct? Do I see that right? Or do you see that implication too?
I actually couldn't understand how we get fund tokens to cross security token line. In which case do you think that fund token will be in fact considered as a security token? I couldn't catch that part.
Which token though? The funding token.
That a fund token.
A meme coin. You mean like a meme coin? Like a meme coin? You mean?
I think you both talk about meme coins, right?
Yeah. I think a meme coin generally it doesn't have an inherent purpose other than being some sort of an art, which where you could say, okay, an art piece of art has the implication of value storage or of rising value, and a meme token is not an NFT, right? Because if it would be an NFT, it would fall out of the regulation currently. That's just the separation of the amount that can be produced and the reproducibility. Oh, that's just a terrible word. But a meme token, as it is understood for today, usually has the implication there's a rise of value and it's an inherent risk of pump and dump. Just by historic value. I know we don't have the historic law system in Europe, but I think the implication is very, very near. But what I mean is, if I have a utility token, if I create a utility token, then from what I see, many projects they bring up a utility token and propagate the message. Hey, at some time there will be a rise in the value of this token, which exactly contradicts the part of the utility token.
Actually, I don't agree with you, because the fact that there is an increase in the value of utility token do not make it a security token. Utility token can be regarded as the Samsung Galaxy Bud. It can, its price may increase, but doesn't change the fact that it's just a galaxy buds. However, the utility that a utility token offers may in fact transform it into a security token in certain cases, but actually, yeah, each case shall be closely examined and determined accordingly. But as you said, I in fact agree that there is a really thin line to cross. So we always advise our projects to advise to a legal expert. I don't know if I managed to answer your question, but if I didn't, please elaborate and I will try my best. Or Asena may help me.
No, this is absolutely clear. It's absolutely clear. Very, very good. Very, very good point. And I understand that. Yeah, basically, you answered the question. And so, to say in layman terms, if I have it framed correctly, a utility token will not become a security token.
Yes.
That was always my inherent fear.
If they didn't reserve the half of it for themselves as a team, then it cannot convert change into security token. The distribution is important in that case. You know, if you fairly distribute it and take nothing for yourself, then it's utility, exactly utility. But if you spare lots of tokens for yourself and for your team, and then it's not so obvious for me.
Yeah, that makes sense. Because why would you keep them if they don't rise in value? If you don't expect a rise in value? Yeah, makes sense. It must be really well argued that you keep them then. Yeah. That is a good one. Thank you so much. Really glad to be here. Thank you.
We are also really glad. So all of you are here and listen to the session. Thank you very much, all of you. We will have another session in 2 or 3 weeks later, and we will announce it like that. And we expect you to come to the next section also. By the way, I will stop recording. Thank you very much.
Thank you all for attending.
Thank you all for listening.